bankruptcy from a creditor's perspective, and I'll let him get going, but I have known him for almost 9 years. Wow. I'm sorry. I'm getting old. I did have the honors of working there for my last job at the Castle Law Firm. So he has been nice enough to come and join us today. So get busy, dude.
I will do. Yeah, Leora and I work together. She's awesome, as you probably know. She babysat me basically, and I needed it, so she took good care of me. My name's Aaron Waite. I've been practicing for almost 20 years. Let me be very clear, I'm not a debtor attorney, okay? So I'm talking today just from the standpoint, bankruptcy from the standpoint of a creditor. So really good debtors attorneys can tell you about bankruptcy planning and exemptions and all that stuff. You're not going to hear any of that from me today. I do mostly creditor work, mostly mortgage banking work, and a lot of car work as well. So mostly secured and some unsecured bankruptcy work as well. And I'm probably going to tell you all things you already know, so if you need to nod off or check your Facebook or whatever you need to do, it's perfectly fine. The two things, if you don't remember anything else I say today, two things you need to remember. Automatic stay and the discharge injunction, right? Automatic stay and discharge injunction. If you remember those things, at least it'll trigger you to stop doing what you're doing and then check to make sure that you're not going to get in trouble with the bankruptcy court, right? Those are the two things. Again, you can fall asleep now, and you probably won't miss anything. But those are the two things you need to remember. So let me walk through the chapters quickly, and then we'll talk more about the automatic stay and the discharge injunction. In Title 11 of the U.S. Code, there are multiple chapters of bankruptcy. Let's just walk through a couple of them. Chapter 7 is liquidation. That's available to a debtor, to an individual debtor, where if the debtor doesn't have enough disposable income to pay towards a plan, the debtor can qualify for a Chapter 7. And in that case, the Chapter 7 trustee would take all of the assets of the non-exempt assets of the debtor, sell them or dispose of them somehow to get money to pay unsecured creditors, right? So in a Chapter 7, secured creditors like a mortgage, a car, those can be dealt with, and those can pass through. The mortgage lien will pass through the bankruptcy, right? The debt may be discharged, so the debtor, the borrower, won't be personally liable anymore if they get a discharge, but in the Chapter 7, a person can keep their house if they're continuing to make payments on their house. They can keep their car. But it's a liquidation. Everything that's not exempt is taken, sold for the purpose of paying unsecured creditors. And often that's to pay cents on the dollar, right? It's usually to pay credit cards, a lot of medical debt that's dealt with a lot in Chapter 7. And there's an asset Chapter 7 and a no asset Chapter 7. I'll come back to that in a minute. An asset Chapter 7 is when there's something for the trustee. There's money for the trustee to disperse. If there's a no asset Chapter 7, then there's not. It's really just, there's no money to be paid out to anybody. Chapter 9 is municipalities. I've never dealt with one of those, so, and that sounds like, who does the power in California? What's wrong with me?
There's a couple.
Pacific? Pacific.
There's SMUD.
Pacific, I think, is on the
Bankruptcy.
brink of a bankruptcy right now. And one question, I was talking to somebody about this, again, I don't do municipality bankruptcies at all, but the question will be, will they be considered, will they be allowed to file in a Chapter 9 as a municipality, or will they be required to file a Chapter 11 or something else? And this is an aside again, but in Vegas, for instance, when the monorail filed, they filed as a Chapter 9, and the bankruptcy judge at the time said, no, you don't qualify as a Chapter 9. Right? So Chapter 9 is municipalities. I've never dealt with one. That's all I know is that it deals with municipalities. Chapter 11 we'll talk about a little bit. Chapter 11 is really it's often a reorganization like Chapter 13, but it's really nuanced. Chapter 11, in my opinion, is just like litigation, right? You just have to you have to treat it like regular litigation. You can't just assume that things are going to happen like they will in Chapter 7 or Chapter 13. We'll get into that more in a second. Chapter 12 is for farms, family farms mostly, and fishing. And then Chapter 13 is a reorganization. That's aimed at individuals, and it allows an individual to come in and say, all right, I'm 5 months behind on my mortgage, I'm 5 months behind on my car. and I need to reorganize that debt. And so the attorney, together with the trustee, will work out a Chapter 13 plan, right? And we'll get into that more in a second. So those are the chapters. So going then first to the automatic stay. As I'm sure you all know, at the second actually that somebody files bankruptcy, automatic stay goes into effect. There are exceptions to that, and I'll get to that in a minute, but for our purposes, we always assume that the bankruptcy stay is in effect. If we run a PACER search and there's a pending bankruptcy, we assume there's a stay in effect, and then we can dig into that a little bit to determine whether or not the stay is in effect. That's in 11 U.S.C. 362, right? Again, there are some exceptions to it, but when the automatic stay is in effect, creditors to do nothing. Mortgage creditor can't foreclose, auto creditor can't repossess, the credit card company shouldn't be calling the debtor saying, you know, hey, are you going to make your payment this month? All that should stop, right? Automatic stay is in effect. And that applies in every bankruptcy. There again are some exceptions. Criminal cases, for instance, may not be stayed by a bankruptcy. But generally, from a creditor's perspective, if there's a bankruptcy in effect, we're going to stop. Some things that are in every bankruptcy, again, there are exceptions to everything, of course. A proof of claim, right? If a bankruptcy is filed, generally a creditor will be expected or not expected. Under the new rules, expected is probably the right word, but a creditor should file a proof of claim. That's the creditor saying to the debtor and to the court, this is how much we're owed, total, and this is what our pre-petition debt was, right? This is what in a Chapter 13 would need to be dealt with. In a no asset Chapter 7, there usually not be a proof of claim required because there are going to be no assets to distribute. And often in a Chapter 7, secured creditors won't file a proof of claim. But generally, if you represent a creditor, there's a bankruptcy, you'll want to file a proof of claim most of the time. Preferential and fraudulent transfers. This affects creditors sometimes, not secured creditors as much. But bankruptcy code says if the debtor has made a payment that's not in the ordinary course, not a payment for groceries, like if within 90 days before the filing of the bankruptcy, the debtor has made a payment that preferred one creditor over the other, the bankruptcy trustee can go back to that creditor and say, you need to give me that money back. Here's some examples of that. So if I'm the debtor and I filed bankruptcy and 2 days before I bought groceries, that's not going to count, right? Because I made an exchange for goods, right? And the court's not, or the trustee's not going to go back and take that money back. But if, for instance, if I owe my dad $500 and 5 days before I filed bankruptcy, I pay him that money in the hopes that that'll get him paid and I won't have to put it through the bankruptcy, the trustee will see that and go back and get that $500 from my dad because I preferred one creditor over others, right? So their preferential transfers can be set aside if they are within 90 days before the filing of the bankruptcy. 90? Yeah. Sorry, my brain just went someplace else. Fraudulent transfers. A transfer to an insider or a transfer for the purpose of hiding an asset, the trustee can go back a year. There are instances when the trustee can go back further, but the trustee can go back a year. So if I know I'm going to be filing bankruptcy and I've got that, 69 T-top Corvette that I just can't stand to lose, right? So I transfer the title to my brother so I don't lose that. The trustee finds out about that. The trustee can go back to my brother and say, you need to transfer that. That's a fraudulent transfer. That belongs to the estate. And that's something in every bankruptcy that's available to the trustee. One more comment on what I refer to as a clawback, right? The preferential transfer, fraudulent transfers, and clawbacks. There are other clawbacks, right? There are other things that a trustee can do. There are other things that a creditor can do. But generally, those are the two that come up most often.
What was the time frame?
A year for a fraudulent transfer.
A year?
A year, yep, 1 year.
Is it the same for real property?
It would be, yeah. Anything, they would be. That stuff often comes up, like if the trustee thinks something's happened, the trustee may file an adversary complaint against, like, my brother and me saying, hey, we want that Corvette back into the estate. But it definitely does apply to real property. It actually applies to anything, whether it's a car, real property, stock, anything that's been deeded or conveyed to Waite.
Does that apply on all 5 of those chapters or just one specific?
It applies in all of them. In a 9 and in a 12, I don't know, right? I've not done a farm one. I'm confident it does because it's in. As you look at the Title 11, you have the 300 sections that apply to every bankruptcy, the 500 sections that apply to every bankruptcy. I think you have 700 sections that are only 7s, you know, the 13s that are only 13s. So I'm confident that it applies in every bankruptcy. And actually, to get to your point, that I can come back to 11s in a bit, but specific to 11s, it is a little different because with an 11, a trustee is not automatically appointed, right? The debtor is deemed to be a debtor in possession, and the debtor is the trustee. So the debtor is the one who's to administer the estate, because often it's the debtor who, if the debtor's a going concern, they've asked the court to be able to continue to make payroll and to continue to do whatever they're doing, then there's not a trustee there who's going to be aggressively going after fraudulent transfers. However, the U.S. trustee will look for those things in those instances. So the U.S. trustee can come in. So I'm confident that it applies in 11, but it may come out a different way. The U.S. trustee may be the one suing instead of an appointed trustee. And often what will happen is a creditor will file a motion asking the court to appoint a trustee, and then that trustee will go back and check bank records and check assets and all that stuff. So, yeah. And so with, at least from a creditor perspective again, if the preferential transfers or preferential payments don't usually affect creditors. They do on credit cards, right? We represent one particular lender that lends mostly to military, right, or former military, families of military. And we deal with preference claims often in those cases where the debtors, they want to maintain that relationship. It's true with credit unions as well, right? The debtor gets certain benefits from being a member of a credit union. By filing bankruptcy in writing and having that debt written off, they may lose those benefits, may lose the ability to be a member of a credit union. So sometimes, in fact, I dealt with one in Arizona recently where the debtor paid large amounts, like thousands of dollars, towards a credit card bill to this particular unsecured creditor right before filing bankruptcy. But the trustee sees all the bank records and just added it all up and sent it to the creditor saying, look, you got paid, whatever it was, we want it back. And there are defenses to that, and we were able to reduce that somewhat, but for unsecured, for credit cards, I think it can happen off of payments to family. Turnover is another issue in a bankruptcy that may affect credit. It doesn't, because of offset issues, which we'll get to in just a second, it may not always affect, or may not affect a mortgage creditor or a card creditor. Right? But turnover is, if I'm holding an asset of the estate, the trustee can come to me and say, you creditor are holding something that we need, that belongs to the estate, you need to turn it over to the estate. And so there are instances where that would be the case. Let me give you an example. A car title has to be perfected within a certain amount of time after the borrower takes out a loan, right? And so if that's not perfected, most of the time it doesn't matter. Let's say that it takes the bank 6 months to get its name recorded against the title with the DMV. Most of the time it doesn't matter. But a trustee can come in, if that lien is not timely recorded, a trustee can come in and say, bank, that's actually a preference to you. You didn't have a perfected lien at the time of the bankruptcy, or it wasn't perfected at the time of the filing of the lien. Therefore, you're an unsecured creditor, that car belongs to us. And this arises occasionally in a case where if the bank has repossessed the car, the trustee can go and say, look, you didn't actually have a lien. You may have had a lien under state law, but it was untimely, therefore, in the bankruptcy law, you're not a secured creditor, you give us that car. So that's where a turnover issue may come up. And then set-offs or offsets. This is one thing that benefits the creditors, right? So a bank can say, look, I'm owed, can set off debt. I'm trying to think of the example I dealt with recently. for instance, the bank, all right, let me back up a little bit. I started 5 sentences there, sorry. My brain will catch up to my mouth here in just a second. So a creditor can, let me expand on this a little bit. A lot of credit unions, for instance, will have what's called a dragnet clause, or in their agreement, it basically says, look, everything you buy is cross-collateralized, right? So it's either cross-collateral agreement, it's been called the dragnet agreement. And so there are circumstances where a bank can say, you know, look, I have an auto loan, but the credit card is also secured by a lien on this vehicle, right? And as long as there's enough equity in the vehicle, a bank can, sometimes we lose on that argument. Bankruptcy courts, I don't think, really like that necessarily, but a bank, a creditor can say, hey, we have a lien, a secured lien on more than just our car. We have a secured, that credit card's also secured, or partially secured, right? And that's kind of an aside to the offset or set off, but it comes up because a bank can also say, look, I may, you know, I may owe the creditor, the debtor some money, but the debtor owes me more money, right? And so in that case, the bank can say, look, when it all washes out at the end, I'm going to end up with the money anyway. So if a trustee comes to a bank and says, look, you need to turn over that money in a checking account, for instance, right? Most of the time, most debtors' attorneys will tell the debtor, make sure there's not a cent in that checking account on the day you file, because it belongs to the estate if there is. But if there's money in there, and the trustee makes a demand to the bank for it, the bank can say, look, sure, there's $1,000 sitting in that account, you know, but they owe me, they're past due $1,000 on their car payment. So because of the set-off, I'm just entitled to keep that, right? So set-off is something that would come up in almost every bankruptcy that I can think of, in every bankruptcy context, right? A secured creditor may have a right to set off. I didn't explain that very well, but it really in my head made a lot of sense. Let's delve into a little bit more, Chapter 7. So it is a liquidation. A trustee is appointed automatically. They're standing Chapter 7 trustees. They're appointed to the case. Early on in the case, a 341 meeting of the creditors is held, where the trustee can sit down and ask questions and say, all right, we're missing this, we don't have, I need these bank records, I need these pay stubs, whatever the case may be, right? Because the trustee's looking to make sure, one, I think that they're not abuses, but just to see if there are any assets that can be available to pay creditors. With regards to a secured claim, let's use a car claim in a Chapter 7 bankruptcy. The debtor really has 3 options. As a practical matter, they have 4, but under the code, let's just address the 3. They can reaffirm the debt, redeem, or they can surrender the collateral, right? So a reaffirmation is, let's say that debtor files a Chapter 7, they owe $25,000 on the car, and the car's only worth $15,000, right? The debtor can, with court approval, could reaffirm that debt. The debtor can say, look, I owe $27,000 on that car, I want to reaffirm the entire debt. But what that means is, there's no discharge on that debt, right? That debt sails through the bankruptcy with no discharge. Bankruptcy courts do not like reaffirmations, for a good reason, because it has to be, bankruptcy courts have to determine if it's in the best interest of the debtor to reaffirm the debt. And rarely, especially with the car, rarely is it going to be. And in fact, mortgages, in my experience at least, courts do not like reaffirmations on mortgages. Because after the downturn in particular, people often owed considerably more than what the home was worth, right? And so a court is not going to let a debtor go through bankruptcy and then not have the mortgage debt be discharged, right? Because it practically doesn't do the debtor much good. In fact, in Arizona, there's a specific case that's come out, and with no exception that I've seen, there probably are exceptions, but on reaffirmations, the courts will always hear it and issue a minute order that refers to that case and says, we're not going to reaffirm a debt. It's not in the debtor's best interest, and as long as the debtor, is making post-petition payments, we'll allow them to retain the card, right? But we're not going to reaffirm the debt. So for secured debt, reaffirmation is there, and it happens. In fact, it happens in Utah more. I practice Utah, Nevada, Arizona, and Maine, oddly enough. So, but it happens often in Utah, reaffirmations do. But Arizona and Nevada, it happens less often. By the way, the bankruptcy judges here are awesome. I'm not suggesting that they're letting something through that shouldn't be through. But the courts in Nevada and Arizona have simply taken the position that we're not going to reaffirm debt. So, reaffirmation is an option. Redemption is an option. The debtor can come in and say, all right, I owe $27,000 on that car, but it's only worth $15,000. I'll pay you $15,000 and redeem that, and I get the car. In fact, there are a whole host of lenders who do what's called redemption financing, right? You can go to a redemption financer and say, and they'll finance the redemption. So you get a new loan, usually at a higher interest rate, but the value is much lower, right? And as long as the court approves it, then the creditor, the secured creditor, gets paid what the vehicle's worth, right? And then there's this new redemption creditor who comes in, and now that's not a dischargeable debt, right? That redemption creditor, that's post-petition debt, and so that survives the bankruptcy. But that's a possibility. What we fight about more in redemption is, most often, is the value, right? People will come in and say, no, it's worth, it's worth $10,000. And we say, no, it's worth 16, whatever the case may be. In fact, I'm using specific numbers on a redemption case that I dealt with this morning before I came up. So, they were at 9, we were at 16. They owed, as far as value goes, they owed 27. So, and the redemption financer would give them 13.3 to redeem. So that's an option. Redemption's an option, and if a debtor files a motion for redemption and the creditor doesn't object, then customarily the courts will, unless the value is way out of sync, customarily the courts will grant those. Surrender is the other option, and surrender is just what it sounds like, right? The debtor says, hey, I can't make these payments anymore, I'm surrendering the vehicle. And usually in conjunction with that, at least from a creditor's perspective, we want the trustee to abandon the vehicle, abandon the asset as well. Because the trustee may have a claim against the vehicle as an asset of the estate. So even when the borrower or the debtor surrenders, we want the trustee to say, yeah, we're abandoning it. And if we prepare a stipulation for a surrender, we'll always have the trustee sign off on it, just to make sure that we don't repossess the car and then have the trustee come back and say, yeah, there was $5,000 in equity in that car, and we want it back to the estate. Lastly, at least in the chapter 7, without going too deep into it, so in 2005 or 2007, I think it was 2005, what we refer to as BAP-CEPA, right? So the bankruptcy code had this huge overhaul in 2005, and supposedly one purpose of it was to push more people towards a chapter 13, or at least make them go through a means test before they could get to a chapter 7. But among other things, what it did was, for practical purposes, kind of eliminated what we refer to as the retain and pay, which is in a chapter 7, the debtor would be able to say, look, Judge, I'm making my payments, I want to keep the car, and effectively the post-petition or the pre-petition debt would be discharged along with the rest of the debt, and as long as the borrower continued to make payments, then the borrower got to keep the car. Supposedly, as I understand it, and I've made this argument, but supposedly the retain and pay wasn't, I don't know if they were intending to try to get rid of it, but it wasn't part of the BAP-CEPA changes. But as a practical matter, it's still there, right? So judges like that. I think it makes sense to them, and I can understand that, right? So even though in the code it talks about reaffirmation, redemption, surrender, as a practical matter, if a debtor starts making their car payment the day after they file a Chapter 7 bankruptcy, most courts will allow them to retain the vehicle as long as they're making ongoing payments. Any questions on a Chapter 7? Fascinating stuff, I know. Chapter 13s. There's also a trustee appointed in a Chapter 13. A Chapter 13 trustee. The Chapter 13 trustee also has a 341 meeting, looks at the books, looks at the accounts, whatever, for the debtor. And then between the debtor and the trustee, the debtor is to propose a Chapter 13 plan. And the plan is to say, look, we're reorganizing the debt, right? So we'll pay out whatever it is, cents on the dollar to unsecured debt, and the rest of the claims will be paid in this way. Administrative claims are paid first, that's like the debtor's attorney, which is fair, that makes sense. Administrative claims get paid first, and then secured claims get paid, and we'll talk about more in a minute how that can be adjusted. There are priority unsecured claims, which is like an IRS lien, right? So the IRS would get paid before a general unsecured, like a credit card will get paid. But that all gets dealt with in the plan. The debtor proposes a plan, creditors have an objection, or have an opportunity to object to it, and most of our objections are, look, our proof of claim says that you're $20,000 past due on the mortgage, your plan only says that you're $5,000 past due. That affects the feasibility because what you're paying will never cover the arrears, and so we will object based on feasibility, based on the fact that the monthly payment's not correct, that the arrears are not correct, anything like that, right? Because once a plan is set, it's set. We don't want, even though there are provisions like, and this is kind of an aside, but for instance, 1325 says that they're not allowed to modify a mortgage debt on their primary residence in a plan. But as a practical matter, if that slips through and the plan gets confirmed, it may bind the creditor, right? If the creditor didn't object, didn't appeal, it could bind the creditor, right? So from a creditor's perspective, we look at the plan really close and make sure that there's no need for an objection, because that's really the chance to protect the debt.
Question. So let's say you're in a situation, you're in Chapter 13 bankruptcy, and then, however, the bankruptcy court still stated you have to sell your house by a certain time, but yet you couldn't find a place for, let's say, 3 months. How would that work?
So if the bankruptcy court won't. You mean if the bankruptcy court was making you sell the home? I'm trying to think. Most of the time, if there's a secured creditor, it would be the creditor taking the home, right? So it wouldn't be the borrower, the debtor could.
Still fall through like
Could-
a foreclosure type of thing.
Yeah. So if it's a foreclosure, usually it would be the creditor taking the home.
Right.
But if they're under 363, the debtor can file a motion saying, I want to sell the home, right? Either because there's equity that we can use, or because it's not worth anything. But usually a bankruptcy court, I think, if somebody's done that, if somebody said, hey, if they filed a 363 motion asking for permission to sell the home and it doesn't sell, usually the court won't make them sell it. If it's if I filed a motion for relief as a creditor and they come in and say, look, okay, but I can't get out, right? I need additional time. Usually the bankruptcy court will say, that's not really an issue in front of this court, right? All we're dealing with is whether or not the creditor has a colorable claim to the property. And if the creditor does, we grant stay relief. So usually they reserve that for let the eviction court, deal with that. Did that answer your question?
Yeah.
Yeah. So that courts are we'll get to jurisdiction in a bit maybe, but just on that note quickly. A case came out within the last decade. We refer to it as the Stern decision, but it's actually Anna Nicole Smith, right, who married this oil baron, I think is what he was, and then he passed away, and there was this nasty fight that went all the way to the U.S. Supreme Court, but it actually went up in a bankruptcy context. Stern versus Marshall is the name of the case, and I think her maiden name is Marshall. I think that's where the Marshall comes from. Not maiden name, not her stage name, whatever the right way to say that is, right? But Stern versus Marshall came down about when bankruptcy courts have jurisdiction, and it kind of came down against bankruptcy courts, right? And so there have been a lot of cases on it since, but bankruptcy courts are very careful, in my experience, to make sure that this is something they have jurisdiction over, make sure it's a court issue, or it has some relationship to a court issue, right? The reason I bring that up is because I think in that circumstance, a court would go, in fact, I dealt with one in December where the foreclosure had already happened. The debtor filed another bankruptcy, and that was the kind of one argument was the debtor was saying, how soon am I going to have to be out, right? But that's just not something for the bankruptcy court to decide, right? The bankruptcy court simply decides if the stay needs to be terminated or relieved or modified, and then those issues should be dealt with by the state court. On Chapter 13 is a couple more things. Secured versus unsecured debt, right? So unsecured debt will be the same. The creditor should file a proof of claim, and then they'll get cents on the dollar, whatever that's going to be, right? After everything else has been paid, then the money will be paid to the unsecured creditors. secured creditors' claims can be modified. In fact, under the new plans, even in the plan, they can be modified, right? What I mean by that is, let's say that there's a first and a second on a home, right? And the first is completely secured and the second is completely unsecured, right? The debtor could actually come in, and we refer to it as a lien strip or as a cram down. You know, the cram down would be reducing the amount of the secured debt. Lien strip would be just stripping that lien, that second lien right off. So in a Chapter 13 bankruptcy, a debtor can modify secured claims. They can modify secured claims on personal property for sure, right? They do that. That's done in the plan all the time. So if, again, back to the scenario, if they owe the credit union $27,000 on that Acura, and it's only worth $15,000, they're only going to end up paying $15,000 through the plan, right? So that value gets crammed down.
So is that the redemption like on 7? Is that the same scenario? Is that what it's called?
Kind of. It's not referred to as redemption. Redemption is very specifically a Chapter 7
Okay.
animal. But it's, we refer to it as a cram down, right? So it's under 506 of the bankruptcy code, allows them to cram the value down, cram the claim, the secured claim down to the value of the collateral. And in fact, what happens is the claim is bifurcated. You have a secured claim and you have an unsecured claim. Unsecured claim drops into the pool of unsecured claims, gets paid out cents on the dollar, whatever that is. And then the secured claim gets paid out at the $15,000 or whatever it is. Mortgages can be crammed down. In fact, the case came out of Utah. So a mortgage, whether it's your primary residence or a rental, makes a difference, right, as far as whether it can be crammed down. But during the pendency of a Chapter 13 case, a debtor can file a 506 motion and say, court, the first position lien isn't even fully secured. They can't cram that down, by the way, on their resident. But they can say, look, that first position lien isn't even fully secured. That second position lien is completely unsecured. And a court can just wipe off that second position lien and make it unsecured, right? So secured claims can be modified in a Chapter 13. Once the plan is confirmed, then it's done, right? That's happened. And confirmation is something I'll come back to in a bit when we talk about the discharge injunction, right? So just one final note with regards to Chapter 13 plans. Utah has not adopted this. Arizona and Nevada have. They have what they call a conduit plan, right? And what that means is if, in Arizona, for instance, if the debtor is past due on their mortgage at the day they file bankruptcy, if there are pre-petition arrears, then it is a conduit plan, which means not only does the debtor have to pay their Chapter 13 payments to the trustee, the debtor also has to pay their mortgage payment to the trustee. The trustee then collects it and pays it on to the creditor. One purpose of this is that so you don't get 3 years into a Chapter 13 plan and then have the creditor finally file a motion for relief saying, look, they haven't made mortgage payments for 2 years, right? It's a way for the trustee to kind of keep track to make sure that that the debtor's making mortgage payments, right? Because another issue that's come up is